Hi, good afternoon, everyone. I see Navjot Singh. Welcome you all on behalf of Text for Business Advisors in today's session, which is based on understanding legal terminologies from text perspective. Now, you see, when we read law, each of us have their own interpretation, and laws are not always plain. I would say when we do read law, you might have some other interpretation. I might have some another opinion on the same. So laws are like that. They are complicated, and everyone is forming their own opinion. But the thing when everything this legal process came into force, so then only we saw that uh, all the judges, all the I would say jurisprudences were not that affirmative, or I would say were not that strong enough to hold a stand or to know to bring to a conclusions. And I would say in past century only, like after 19th century only, we see jurisprudence is becoming more stronger. If we see from any laws perspective, be it like tax law, civil law, or any economic other laws as well. So that's why it becomes important that laws and interpretation become consistent, and there should be a consistency in the law. And from that perspective, if we see the judicial pronouncements, if we see the judicial process, so what we are doing and what we are going to, that we are creating some principles, we are creating some benchmarks, or I would say some sort of laws or rules that we can bring some more consistency toward the law, and how do we read it and how do we use all these principles. So we thought of bringing on discussing on four important, I would say, legal terminologies, which is first one is law of precedence, then there is a doctrine of merger, then obiter dictum, and ratio decidendi. Now, we will be discussing, I would say, a brief of all these principles, because many of you might be aware from, what is the use of all these principles when we talk about all the jurisprudence, or, how should we read about this, or if even if we are into pleading, or in an argument profession, or be it like in a law profession. So how do we use it? So many of you must be, knowing all these things. But our, I would say, agenda of bringing this session is how do we read all these principles and how we can use these principles in, I would say, in text laws. So in today's session, CA Archana Jain will be joining us in a while. And so firstly, we are starting with law of precedence. Now the thing is, all of us are learners, and we all are learning the law. No one is educating anyone about anything. It's just my opinion about all these principles. And with the given time, we are not going into much detail. We are not going into much deep, because a lot of case laws, a lot of, I would say, uh, different opinions might be there when you will be, I would say, end up listening to us. So we are just giving our opinion to this. So we are starting with law of precedence. Now, what is law of precedence? जैसा कि मैंने स्टार्ट भी किया था, that consistency is the cornerstone of the administration of justice, and it is with a view to achieve consistency in judicial pronouncements that the court have evolved the rule of precedence. And principle of stare decisis is a rule. Now, what is the agenda, or I would say what is the uh, need to bring this rule is to bring some consistency in the administration of justice, to bring justice. And justice is something, it's our belief in that process, which would, I would say, it's kind of an administration of a law process, that we will get justice, not just to bring the consistency. That now, if you are thinking about some, if you're reading I would say, judgment, and some other person is also reading a judgment, and the judge is reading a law, so three of them somewhere should reach at some point of time, this is the conclusion, or this is the, I would say, rule or principle to read this law and to come on a conclusion. Now that consistency is very important. Now, if we see the Black Laws Dictionary, which defines stare decisis as doctrine of precedent under which it is necessary for a court to follow earlier judicial decisions when the same point arise again in the litigation. Now, what do we mean by that? It is something which says that uh, it's something which says that it's kind of a doctrine of precedent which says that court can follow the earlier decision. जो decision पहले किसी court ने दे दिया है, किसी litigation में, किसी point of law पे अगर कोई decision आ चुका है, तो उनको वो follow करना है. इसको थोड़ा और डिटेल में पढ़ते हैं. The doctrine of precedent or the principle of stare decisis would mean that a single judge of a high court is bound to accept as correct the judgments of courts of coordinate jurisdiction of division benches and the full benches of high court and of the Supreme Court. That means if a single judge is giving out or is involved in some sort of judgment, giving some judgment, so he is bound to follow the judgment which is given by fellow division bench of the same jurisdiction or of the full bench of the High Court or by the Supreme Court. So he's bound by that. That means that he cannot decide on any point, or I would say on any law interpretation which is already cited by a full bench or division bench of that particular same High Court or by the Supreme Court of India. That is just again that idea behind the whole process is to bring consistency so that High Court does not waste that much of time in, I would say, in doing the interpretation of the same matter again and again. Apart from it, the corollary of rule is that the courts are bound only by decisions of higher courts, not by those of lower or equal rank. This is something that when a court is giving out some judgment, so he is not bound by the decision of the equal rank of court. Like a single judge is not bound by the decision of a fellow single judge judgment. He is only bound by, I would say, higher courts only, not by the lower courts. Like if a session judge is giving out some judgment, so high court ruling or high court judge is not bound to follow that judgment. He can overrule that. So he's not bound to follow the principles or interpretation which are used by session judge. Apart from it, a underlying principle of doctrine precedent is that normally the court should maintain the finality of judicial decisions and finality of binding precedents. That means finality, what do you mean by finality? That the judicial process has been completed in respect of any, if there is a matter, suppose in GST or income tax, there is a section on which there are some interpretational issues, and Supreme Court have cited that yes, this section will not be applied or applicable to any notified category. Now, after that, that judgment has, or that particular, I would say, dispute has attained the finality. You have got your answer from Supreme Court that how the interpretation should be done in this respect. Now, the principle of law of precedent is to maintain, or I would say, maintain that finality of that judicial decision, so that it doesn't change again and again. After that, it's, if we see other countries' laws as well, if we see the legal system, because our legal system was adopted from the England, and if you see the judicial system of US or another, I would say, prominent countries, so they also follow this rule of law of precedence. Apart from it, the doctrine is embodied under Article 141 in the Constitution, which states that the law declared by Supreme Court shall be binding on all courts within the territory of India. That means, if we see the Article 141 of Constitution, which says that जो सुप्रीम कोर्ट का जजमेंट है, जो सुप्रीम कोर्ट ने लॉ डिक्लेयर कर दिया है, किसी लॉ को उसने अनकॉन्स्टिट्यूशनल बताया है या कॉन्स्टिट्यूशनल बताया है, तो जितने भी कोर्ट्स हैं विद इन टेरिटरी ऑफ इंडिया, that particular ruling will be binding upon them. They cannot, I would say, rule out something which will be going against the ruling of Supreme Court. Now, if we talk about particular taxation as well, if there is a chapter 20 of Income Tax 1961 Act, which deals with the appeal and revision. And if you see, the doctrine of precedents may be derived specifically from the sections in that particular act, which is section 256, 257, 260, and 261, which is related to revision and filing appeals before various forms, and which deals with the, all these sections, which somehow kind of give us, I would say, there is a line, and from these sections, this line starts and it ends on justice. Now, to bring all the facts and figures which are based out in a particular section, or the powers which are given to you in which you file the appeal before all these forms, it is very important that when these forms decides anything in respect of tax laws on particular Income Tax Act, So they follow some kind of, I would say, precedent, because in income tax per se, if we talk about tax rules or tax laws, there might be matters which are similar to each other, so it is very important that they maintain that law of precedent, so that one court is not much paying attention to the same matter again and again, or the question of law again and again. Yes, there are some basic elements on which this rule, or I would say principle, is based on. Now, what are these three basic elements which would be there? First one is findings of material facts, direct or inferential. Now, what do you mean by inferential? That is anumanic. Like, if it's not like a procrastinating, but it's something that there are some material facts that can be direct, and there are some facts which cannot be direct but indirectly related to that particular matter. So that is also very much important, because that inferential finding of facts is something inference which the judge draws from direct, or I would say perceptible facts. It cannot be embedded in that particular, I would say, matter, but judge applies his own, I would say, learned mind, that this, yes, this particular rule or this particular, I would say, section is problematic, and it's creating some issues related to point of taxation, maybe place of supply. So this particular section is creating some problems. So there might be some issues, or there might be some facts which are directly related to that particular problem, and there might be some other facts as well which are not directly related to that particular matter. But both the matters are equally important when we talk about this particular precedent rule. Now, second basic principle is statements of principle of law applicable to the legal problems disclosed by the fact. Now, there might be some legal problems which can be, I would say, disclosed by fact only, not by the law. Because when we are, I would say, unpacking or unresolving the puzzle, which is in that particular matter at that particular time, the statement of principles of law which is applicable to that particular rule already. I'm not talking about the precedents. See, we have to keep two things in our mind. We are reading this rule with a mindset that, yes, if already a ruling, or I would say a cited rule or judgment is already there, so we are not going into facts, so we are not deciding on merits, or I would per se. We will just see that if matter is identical to that matter, so we will say, yes, you can refer that judgment, and because of that judgment of Supreme Court, we are giving this ruling. Supreme Court itself follow the rule of precedent, and through Article 141, it is applicable on the lower courts. So that's what I'm saying. There might be some principles, or I would say statements, which are applicable to that particular legal problem, which you can disclose by fact. So after getting that particular fact, you'll come to know that, yes, whether I can apply the law or principle or doctrine of precedence or not. Again, then there is a judgment based on combined effect of the same. Now, if we talk about findings which judge applies his mind, and there are material facts on the record, there might be some facts which are not on the record, and there might be some statements of principles which are already applicable to that. And after coming to conclusion of, I would say, analyzing both the things, then you, I would say, come or draw a conclusion or a judgment. All these basic, I would say, principles or elements plays a very important role, that when you will be applying this particular rule of precedence. Now, what would be the scope of, I would say, this particular doctrine? So if you see the trite law, that under the doctrine of precedent, high courts are not bound by the decision of each other. What do you mean by each other? That a High Court of Rajasthan is not bound by the decision of High Court of Bihar. So that's something which is, I would say, this is a trite law, that this is a cited thing which we don't need to discuss again and again. Now, if we talk about specific to taxation, it has been held that the structure of tax law itself depend upon the fact that itself encourages High Court to have their own separate viewpoints. So if we talk from tax point of views as well, so you see in GST, there was a judgment in VKC Footwear of related to Rule 89.5 of inverted duty structure, that why capital goods or I would say input services are not included in the calculation of refund. And a similar question of law, Madras High Court gave some another judgment. So that's something that law itself provide that liberty that high courts can have their different opinion. And suppose if in future Supreme Court decides in favor of SSA in respect of Rule 89.5 that yes, these input service or capital goods should be included in that refund, I would say refund formula. So at that time, this matter will attain the finality, and then it will become a doctrine of precedent that when in future, if any matter comes related to 18.5, then we will be having a ruling that yes, this on this question of law, the matter, or I would say this rule or this law has already been cited. Now you might feel that in sometimes the law might get changed. See, because Supreme Court cannot create the law, it only reads the law. So there is a limitation on the Supreme Court as well. The legislation, or I would say executive machinery of this particular India, the one who will create the law, the parliament creates the law. Now, if suppose after getting some adverse judgment, there might be a possibility that legislation can change the law. So at that time, that this law of precedent cannot be applicable, because at that time some another, I would say, legal principles related to natural justice, or maybe I would say legality of retrospective amendments can be there. But this doctrine of precedent to apply will be very difficult, because facts have been changed, law have been changed, and in a perspective we do see the change, or if in a perspective we do read about the law, that is also have been changed. So at that time it will be very difficult to apply this doctrine of precedent. I'm not saying that it will not be applicable, I'm saying that it will be difficult to apply that. So all these matters, or all these fundamentals are related to this particular doctrine. Now, related to this, I would say doctrine, there is another Latin term which is res judicata, which is similar to this. So we'll discuss about this. That in a case, there is a case law of CIT versus Brijlal Lohia and Mahabir Prasad Khemka, which can be analyzed in this respect. And that question, in that case, the question issue was with regard to genuineness of two gifts made by the assessee. Now, in respect of assessment years 1945 and 46 and 1946 and 47, the tribunal had found that said gifts were not genuine gifts. And the High Court did not interfere with the said finding of the tribunal on the view that it was a finding of fact. As you know that High Court and Supreme Court doesn't discuss case or doesn't accept the appeals which are based on the facts. They only accept the appeals which are based on the law. Question of law should be there. And after that, Supreme Court also affirmed the said view that yes, this particular whatever the tribunal have decided is right. Now, in subsequent year, in respect of subsequent years in 1947-48 till 1951-52, the assessee produced some additional evidences, and the tribunal, after taking into consideration the said additional evidence, came to the conclusion that gifts in question were genuine gifts, and the Supreme Court held that the fact in the earlier proceedings, the tribunal took a different view of the two gifts were not a conclusive circumstance, and the decision of the tribunal reached in those proceedings did not operate as res judicata. The doctrine of res judicata would not be applied to tax assessments, and hence the court have right to re-examine the case between the same parties on the identical questions of effect in different assessment years. A decision taken by authorities in previous year would not stop or operate as res judicata for subsequent years. This is related to law of precedent. Now, what would you say that if assessee who have kind of received some gifts, or he might have some gifted some things to some other person. Now, there was a question that whether these particular transfer, or I would say when these gifts were given, so whether these gifts will be taxed in a manner. So there was a question on that. Now, what happened in this particular, I would say, judgment is the tribunal said that these are not genuine gifts. First of all, in first two assessment years, it said that these gifts are not genuine gifts, and we will not treat it as a gift. It is related to some income tax issue. Now, after that, High Court said that it will not interfere, and later on, for subsequent years, when assessee produced some additional, I would say, circumstances, and assessee proved that why these gifts which are given in, I would say, subsequent year is a genuine gift. So at that time, this particular doctrine of res judicata will not be applicable because the facts have been changed. So at that time, it will be very difficult for the court to reassess, because in tax reassessments or assessments, if you see, when we talk about reassessment, then when you re-examine the case, you might produce some additional, or I would say identical question of facts which are involved in that case, and which were not available back then in, I would say, in previous assessments, but these are available in present, I would say, assessment. So you cannot decide a rule that yes, because tribunal decided that yes, these are not genuine gifts, not genuine gifts, but now when you are having some additional grounds, or I would say additional facts, that yes, these gifts are genuine gifts, so they can, it can change. Then law of precedent, or I would say doctrine of res judicata, will not be applicable. Now, in this regard, if we see the some position in England law, so that is also, I would say, unambiguous now, because with respect to non-applicability of res judicata in tax matters. But earlier, the courts had come to opposing viewpoints in this matter, because when we talk about assessment of tax laws, again, I would repeat in this that facts might change in each of the assessment, or like in GST, they have a power to assess our each month's, I would say, returns which we do file. So facts related to one return, maybe in a March, you are having some issue. Similar issue is in, I would say, in April next year. But yes, the backings and why that mismatch, or why these things are different in both the assessments cannot be decided, taking this ground that, we'll take that law of precedent that yes, whatever we have decided earlier, we'll decide that now as well. So they cannot do that. But yes, in England, there was a, I would say, ambiguous situation earlier in a Broken Hill Proprietary Company versus Broken Hill Municipal Council's case law. In that case, the court held that assessment in previous year would not stop the parties from re-litigating the same question of on a subsequent year assessment. This was a case law which was in England. Now, in a Hoisted versus Taxation Commissioner, this particular lordship took the contrary stand, and it said that they cannot go for re-litigating the same issue, and the assessment which is cited on a particular matter will be, I would say, will become a rule thereafter to be decided in subsequent, I would say, assessments. And after this judgment, there was the picture become hazy that that two views were there, that these tax matters, I would say, the assessment of tax matters can be subject to res judicata or not, or the doctrine of precedent can be applicable in assessments as well. But there was a case law of, I would say, a full bench of court in the case of IRC versus Smith, where the court explicitly stated that although a decision reached in 1 year would be a cogent factor in the determination of a similar point in a following year, but it could not be treated as an estoppel binding upon the same parties for all years. That is something which is, I would say, a principle in India as well, that in reassessments, there might be some other points, there might be some other facts. So assessees go and litigate on those points as well. And at that time, law of precedent of res judicata is not applicable at that time. Now, similar to this thing, there is a case law of MMFO versus Commissioner of Income Tax of Madras High Court, in which the doctrine of res judicata doesn't apply so as to make a decision on a question of fact or a law in proceedings for assessment in 1 year binding in another year. Not only decision at an administration level, but also those by the courts of competent general jurisdiction fall within the exception to the general rule. And no estoppel can be founded upon them when the same point is raised again in the another year of assessment, or is in respect of list other than the fixed in original decision. So there might be some at the time of reassessment, when we talk about this particular rule, so the time of reassessment, there might be some other issues which are not being decided in the original decision or in the original order. So on the basis of those new formal decisions or those new findings, this reassessment cannot be based upon this particular doctrine. Now, the second principle, which is doctrine of merger, which is also, I would say, on the basis of that previous principle we just discussed, that the doctrine of merger is a common law doctrine, which is founded on the principle of propriety. In the hierarchy of justice delivery system, the underlying logic of doctrine of merger is that there cannot be more than one decree or an operative order governing the same subject matter at the given point of time. That is that the principle is similar to the doctrine of precedent, but it says that on the same subject matter, or I would say on the same question of law, you can say that there cannot be more than one order on the same matter. And this particular doctrine of merger can be better understood from the following observations of Supreme Court in landmark decision in the case of there was a case law of uh, Kerala High Court, which I think it was adversely applied by High Court and subsequently reversed by the Supreme Court. And what were the findings, or I would say observations of the Supreme Court were the where an appeal or revision is provided before a superior firm against an order passed by a court, tribunal, or any other authority, and such superior firm modifies, reverse, or affirms the decision put in issue before it, the decision by subordinate firm merges with the decision by superior firm, and it is latter which subsists remain operative and capable of enforcement in the eyes of law. The doctrine of merger is not a doctrine of universal or unlimited application. It will depend on the nature of jurisdiction exercised by superior firm and the content and subject matter of challenge. This can be better understood from I would say, from income tax point of view, wherein the Act gives the power of assessment and reassessments, and wherein if any matter which is uh, which is already being litigated, when I would say if you are challenging your assessment or any of the point which is made out in assessment before High Court or Supreme Court, and subsequently if reassessment is there for the similar assessment year, and some other points are there, so that doesn't mean that your original order also get modified or somehow it doesn't exist, but the new points which are added or modified by the authority, it also get added to your main decision. So, and those particular separate decisions works as, I would say, separate, and you can separately challenge them, or they have they're capable of enforcement in IF law separately. And apart from that, obviously this particular rule will applicable only after saying that what sort of content or subject matter of challenge. We will see that such, just like basic principles which we read in doctrine of precedents, there are some principle in this as well. As I mentioned, that there is no doctrine of universal or unlimited. There is no unlimited power which is given through this doctrine, but this is just to prevent a subordinate authority to give a separate decision which on which you are already having a one order by the, I would say, superior authority. Same judgment or similar uh, observations were given in some CIT versus Langendran Finance Limited, which said that when an order of assessment is reopened, the previous assessment will be held to be set aside and the whole proceedings would start afresh. But the same would not mean that even when the subject matter of reassessment is distinct and different, the entire proceedings of assessment would be deemed to be have reopened. So you would have gotten the sense which is coming out of doctrine of merger. There are some other judgments in Ashoka Buildcon Limited versus ACIT, and a lot of judgments related to Section 43, subsection 3 and 147, wherein reassessments are continuously done by the Department of Income Tax. So you can, I would say, get a sense that why this doctrine is important. The next important aspect of obiter dictum and ratio decidendi will be taken by my colleague, C. Archana Jainji. So I'm just giving you the right. So yes, you can access.
So Navjot, then I will be able to access the same PPT.
Yes.
So thank you, Navjot. And you have very well explained the law of precedence and doctrine of merger. And these are very important terminology when with respect to the jurisprudence is concerned. And yes, we have seen that nowadays there are plethora of judgments that are being settled on a particular issue. So this is going to be a big rescue for even the persons who are following the similar kind of litigation in their matters, where the matter is almost on the same lines and where they can have the benefit of this law of precedence or the law of merger also. And now carrying it further, where the set has been perfectly set by Navjot, so I'll just carry it further. So there are another important aspect or two important terminologies that are to be taken care while we are dealing with the litigation aspect or dealing with the jurisprudence. So they are obiter dictum and ratio decidendi. So these are there is a very thin line of differentiation between these two terminology. So we'll see what exactly it is. So technically, apart from the findings of material fact, a decision can flow from two bases. One is ratio decidendi and the other being the obiter dictum. So any decision which has been taken or which has been pronounced or which has been awarded, it is based on some material facts, some material circumstances, or some material information or documentation. So we can always bifurcate these two information or documentation or the facts in two bases on two basic categories. One is the important facts or the material facts, which will be the deciding factor of that particular award or particular judgment or particular order, the way it will be decided, and others are the peripheral supporting documents or supporting evidences or supporting facts that would be considered while deciding that fact or deciding that matter, but they may not be holding that role of an important fact or important material fact the way the other facts may would have hold it. So in shorter way, I can say that there are two different aspects. One is one which are the facts or which are the stepping stone, stepping on which we will be ultimately reaching the final verdict or final judgment. But there may be certain other aspect also, let's say, which will be helping us to reach those ladder or reach those stepping stone, by virtue of which we will be ultimately deciding the facts. But these are also equally important. So they may not be forming the part of the consideration while deciding the facts or deciding the matter, but these are again the facts or again the incidences or the information which would have been discussed in the decision making, and which could always be referred by the other judicial members also, or in other matters which are being decided on the similar lines. So ratio decidendi of a judgment may be defined as the principles of law formulated by the judge for the purpose of deciding the problem before him, whereas obiter dicta means observation made by the judge, but not the essential for the decision reached. So these are the observation, information, or the peripherals around which the judgment will be decided. So it is a Latin phrase meaning something said by the way or incidentally. Obiter, presumably unnecessary to the decision, may be an expression of a viewpoint or sentiments which has no binding effect. So these are the things which you may refer, but they don't have the binding effect. So as the ratio decidendi, on the other hand, will be having a binding effect also. The apex court in the case of Arun Kumar Agarwal versus State of MP held that the obiter dicta is a mere observation or remark made by the court by way of aid while deciding the actual issue before it. So these are the aiding factor or the peripherals, as I have already discussed. So these are the observation or remarks that would have been forming a part of that particular judgment or particular award. The mere casual statement or observation which is not relevant, pertinent, or essential to decide the issue in hand. So they are not they can be said as some observation or some casual statement or some findings that the court may have found while deciding that particular matter. And said the court has said did not form the part of the judgment of the court and has no authoritative value. So yes, you can have a referential value, but okay, they are not having a binding factor value. At times, while referring to certain hypothetical question or some observation made on the broader aspect of law by the judge, or certain questions of fact which the judge or the other side counsel may think has not arisen, may be referred, discussed, and stated in the courtroom. Like an example, like some incident that may have occurred on the similar lines. In such a scenario, not all can form the essence or the ratio decidendi of the judgment. So you cannot quote each and everything that has been decided or that has been discussed in the court of law as a deciding factor. But yes, something which has been taken care of, or something which has drawn some extra attention, that need to be referred. Thus, every passing expression of a judge, however eminent or a casual remark, made while deviating from answering the actual issue pending before the court, cannot be treated as ex cathedra statement, having the weight of an authority. So there may be a number of things that would have spoken during the conversation, during the argument, during the litigation proceeding, but everything should not be forming a part until unless this has some kind of relevance or some kind of authentication or some kind of something that you can always rely upon whenever you will be referring those cases. In the case of Madhav Rao Jivaji Rao Scindia, the apex court, while stating about the relevancy of obiter dicta, held that it is difficult to regard a word, clause, or an expression occurring in a judgment as the full exposition of law, even if it is not answering the direct question of law to the case in hand. Thus, it can be well concluded by mentioning that obiter dictum is an opinion not necessary to a judgment and is an observation as to the law made by the judge in the course of a case, but not necessary to its decision and therefore of no binding effect. It is a remark, by the way. It is the ratio decidendi which has the binding effect and the precedent value. So yes, any time when you are referring to something which is of the nature of obiter dicta, so the other person who is the deciding factor in that particular matter, he may disregard those facts because it does not have any binding effect. It does not hold any precedent value. But yes, in case those items are even, or those informations are quite informative or quite, what should I say, they are still having some kind of, holding some kind of importance to that particular matter. And if the same kind of matter is being decided again, then obviously those things can always be referred in the other matter also. There is a logical
There is some technical glitch at the side of Archana ji. So I'll just take the slide for as of now, that there is a logical dichotomy between if you see, there is a descriptive ratio decidendi and the prescriptive ratio decidendi. Now, why that is important? Because we may be able to identify the ratio and in precedent case, but it is not possible to directly apply it in the future case. Sometime it might happen that few of the facts which are related to it are directly relating to the which can decide the future case or the future I would say any case law to come in the future. That reason being, the precedent case and the future case will never be precisely identical, because there might be a point wherein we can say that both the issues, or I would say both the cases, are completely not identical, so that we cannot apply this ratio decidendi or that particular doctrine per se directly. Now there will be always distinctions between the two, or between the issues. Now what is the probability that identical facts in the past will occur in the future as well? So if this is kind of a hypothetical situation, or I would say a situation wherein we'll be asking this. Now, Archana ji, yes, you can carry forward, yes. You're in mute. Just mute. You are on mute. Okay, so I think again there is some technical problem on our side. So I was saying that there might be a possibility when two of the matters might not be having some identical facts. So there is I would say very slim possibility in future that this particular ratio can be applied for a future case or not. So we will see the level of generality as well, that how these the current case law which we are talking about of the descriptive ratio decidendi is applicable to the future case law on the basis of that generality, the level of generality. Yes, ma'am.
Yeah, so I hope you have discussed this perspective ratio decidendi. Okay,
yes,
so
yes,
there
yes.
will always be a distinction between the two. What is the probability, the incidental facts in the past will occur in the future very same. I mean, you cannot correlate the two things, that how they are going to happen or how they are going to be decided. Thus, there needs to be a level of generality also. It is not getting changed. Okay.
I'll do it for you.
Yeah, then the level of generality. We define that the level of generality as the transformation of a single judgment to the future judgment. Inevitably, a transformation need to occur, as the precedent may be utterly useless if we wait for the exact fact of the case to the exist again. Obviously, we have seen, and at times we have seen that the officers only do one thing: they just write the facts are not similar to the case that has been decided, and so he's not relying, he's not placing his reliance upon the same. So, but you cannot have similar kind of fact, each fact to fact basis, you cannot compare. But yes, you have to see what is the basic essence of that case that has been decided, and what is the essence of the case in hand, whether the same can be applied to this particular case or not. Thus, the level of generality in the determination of how similar or different the fact need to be from the old case to the new case. So there has to be some kind of distinction or some kind of line to be drawn, that yes, these are the different issues which are different from what has been decided earlier, or what are the issues which you cannot say, or they are not in the similar lines the way they had been decided in some other judgment. So just by mentioning a single line, I have seen many officers are just doing one thing, that because the facts of the case are not similar to what has been decided in this particular matter, so we are not placing the reliance on the same. And there may be something which has been even decided by the apex court. Still, they will not be, they will not be ready to accept the decision of the apex court also, in case it is not in their favor. Otherwise, whatever has been decided in the favor of revenue, they will always apply this principle, and they'll drag whatever way they can drag that particular case in the particular matter. So it is permissible for the High Court to overrule the decision of the apex court on the ground that Supreme Court laid down the legal position without considering any other point. So whatever they have decided, you cannot just ignore them, that yes, something has not been put in front of them, or something would have not been enlightened to the court while deciding the particular matter. If something has been decided, even in the absence of some kind of facts or the relevance of the data or the document that should have been relied upon, but still that judgment will be holding good, and you cannot just deny on the ground that something was being missed out while the proceedings were